My name is Emil Ali, and I'm a partner at McCabe & Ali LLP. I'm excited to have you all join us at the upcoming ABA-IPL Spring meeting, where I'm going to be moderating a panel entitled Managing Malpractice Risks and Ethics Complaints in Intellectual Property.
Hello, my name is Kenya Gramblin. I'm a law student at University of New Hampshire, Franklin Pierce School of Law. I will be a law student reporter at the 2022 ABA-IPL Section Annual Meeting, IPL Spring. I hope to see you in Washington, D.C., April 5th through 7th. What is the most common cause of malpractice claims or ethics rule violation?
So Kenya, that's a great question. Some of the most common causes of malpractice claims or ethics rule violations against IP practitioners include the normal ones that are applicable to most lawyers. But I would say most specifically, I would say that attorneys should really be cognizant of conflicts of interest and client communication. I think those two are probably the largest areas of concern. So a issue related to conflicts would be, having two clients with competing interests, right? Purely economic interest may not be a problem, but sometimes they're competing for maybe the same thing, whether it's the same type of trademark or a patent in the same area. Those are areas of great concern. And then, other issues that could come up include areas involving financial issues, but also mostly client communication. Did you let the client know of a problem? Did you instruct them on the best course of action? And maybe did you reduce that to writing?
Hello, my name is Taylor Dubell, and I'm a law student at Western New England University School of Law. Prior to my time at Western New England, I got my master's degree in fashion law from Fordham University School of Law, where I primarily focused my studies on intellectual property. I will be a law student reporter at the 2022 ABA-IPL Section Annual Meeting, IPL Spring. I look forward to seeing you all there. What is the best way to handle clients who wish to misrepresent facts, such as date of first use or things of that nature?
So Taylor, that's a great question. When it comes to misrepresenting facts, obviously as officers of the court or lawyers, we want to avoid being part and parcel to any misrepresentation. In fact, if we have a client that wants to misrepresent something, we may have an obligation to correct any previous misstatements if we want to continue to be part of that representation. So if I had to succinctly put this, I would say it's our duty to make sure that we advise our clients of the problem with misrepresenting things. So for example, if your client was to misrepresent or ask you to misrepresent a fact related to the date of first use, right? That could create an issue down the road, as we've seen in some recent trademark cases, but also on the patent side, it could lead to allegations of inequitable conduct. So not only should we advise clients not to misrepresent facts, but we also need to make sure that we comport our conduct to our various obligations, whether it's 37 CFR 11.303 or 37 CFR 11.18.
What is the best way to handle when a conflict of interest arises when you have two clients with potentially conflicting marks?
I think the best way to put it would be, it's really something you need to focus on. It's an ever-changing process, right? And what I mean by that is whether you're representing a client in a patent or trademark matter, but in this case, you're talking about potentially conflicting trademarks, we really need to make sure that we have a process in place. So for example, as lawyers, we usually have some sort of a specialty or a niche that we end up in. Whether it's a beverage manufacturer or technology company, we might represent multiple clients in the same space. However, this could become a problem, right? Because we might, for example, come to know that one client wants us to file a trademark today, and the other one says, oh, we're thinking about potentially filing a mark or expanding into another area, right? And so we have two sets of information. And this creates quite an issue even before the client even files the mark. Why? Because there's potentially confidential information. It might be trade secret information. And this is why it's very important for us as lawyers to ensure we continuously monitor our conflicts, right? Continuously update our conflicts databases to make sure we don't come across these issues. But when they do come, it is something that needs to be examined, because there might be a waiver that might be useful, but in some cases, a waiver may not be appropriate because both clients already want the same thing. And patents and trademarks are not traditionally a zero-sum game, but in some cases they can be.
Hi, everyone. My name is Christina Yana Crosdale, and I'm a 2L JD MBA candidate at Howard University School of Law. How should current law students interested in intellectual property approach their professional responsibility courses to aid them in preparing to enter this specific practice area?
So Christine, that's a great question. You know, when I talk to law students, so I teach professional responsibility at a law school. And, when I talk to my students, I usually like to ask them what field of practice they're going to be in, because I think depending on the field of practice, your view of professional responsibility or legal ethics is going to be different, because there are a great number of nuances, right? If you're going to be an estate planning attorney, the amount of information you need to know about a certain specific area, not only of the substantive area, but also of legal ethics, is going to be quite different than if you're going to be practicing IP law. But even between trademark and patent law, there are different areas you want to focus on. If I had to succinctly say it in just this brief moment, I'd say it's really important for IP lawyers to pay very close attention to subject matter conflicts. And subject matter conflicts are a subset of traditional conflicts, but I like to see them right in between direct adversity and material limitation conflicts. So I would really focus on understanding subject matter conflicts, but I'd also focus on understanding, what it is you are trying to do for your client. So if you're doing patent litigation, that's going to be very different than, for example, patent prosecution or trademark prosecution or trademark litigation. Each one of those areas is going to be very unique. But within IP, because of these niches and specialties that we create, it's important to understand what you're doing for a client, right? Are you providing a full representation, or are you providing a limited scope representation? So that's another area of concern. And then also the other final area would be the unauthorized practice of law, because a lot of us, might be working in what we consider to be a federal practice area. But within the federal practice area, there might be areas of state law that we're working on. So how do we know whether we are kind of going past that UPL construct and, staying outside of the lines or the lane that we're supposed to be in? And that's where we look at cases like Sperry v. Florida.
My name is Daphne Epe, and I am a law student at the American University Washington College of Law. I will be a law student reporter at the 2022 American Bar Association IP Law Section Annual Meeting, IPLSPRING. I hope you join us at the conference in Washington, D.C. Based on your experience with representing IP practitioners, what would you say is the cause of these ethical violations?
So Daphne, it's really hard to say what the root cause of ethical violations are. I wouldn't say that there is one cause, but I will say that in a number of the cases that I deal with, there's always going to be folks that just made a mistake, right? They made a mistake because they missed a date. They missed the on sale bar date, right? They missed a conversion date. They forgot to communicate with a client, right? Those are small issues. That's why we have insurance, right? Practitioners get insurance because we all make mistakes. We have family obligations that come up. We forget, maybe a system crashes. But there are other areas of concern, and I will, this is a conversation that I really am passionate about because I deal with it on a regular basis. I have many clients who just have substance abuse problems or mental health issues, and that is an issue that's plaguing not only the IP community, but really the broader legal community. So we do have attorneys that unfortunately have issues with drugs, alcohol, or mental health issues. So I would say definitely beyond, the normal, I forgot problems, there are systemic issues with practitioners just facing issues at home or in their personal lives.
Do OED have a way of verifying complaints before deciding to prosecute? And based on your experience working with OED, do they have prima facie cases worthy of prosecuting?
So Daphne, when it comes to OEDs, verification of complaints and how they make sure that they have a case worthy of prosecuting, it's an imperfect process. Obviously, OED's charge is to neutrally investigate and then ultimately prosecute potential misconduct. Just like police have problems, just like DAs have problems, the OED has problems, right? They have to make a decision. They have some discretion in making that decision. But in terms of verifying complaints, it's very difficult to verify a complaint without getting the attorney's side. But one of the problems with getting the attorney's side is we're dealing with issues related to, hey, if we send a letter, if OED sends a letter to an attorney, they're going to get very scared, right? They're going to have to hire counsel, and that counsel is going to charge them. And that's going to, obviously cause some stress, both financial and personal. But when it comes to, do they really have a prima facie case, it's helpful to understand how the process moves along. So, once the OED gets the complaint, they make an initial determination about whether there is potential issues, right? So once they find potential grounds for an investigation, they might hand it over to a staff attorney who will do some sort of investigation, communicate with the potential grievant as well as the potential respondent. Once you go through that communication, there might be some letters back and forth. Then they will send it to what they call the Committee on Discipline, which is similar to a grand jury. And that's really where they're going to be finding out whether they have, let's say, probable cause to file a complaint before an ALJ. After that process happens, there's usually a hearing. And once the hearing happens, there's other areas that lawyers can continue to fight. So there's an appeals process, there's reconsiderations, and it can go all the way up to the Supreme Court if they decide to hear it. So, in terms of verifying and going through the process, again, it may not be perfect. It may definitely not be fun for the practitioner, but I think there are some belts and suspenders that will help you as a practitioner know that there are some steps taken before it goes too far.